Welcome to Primary Sources. I'm Jason Beats. If I sound a little different this episode, it's because I've been sick the past few days. With that out of the way, let's get started. Oklahoma Governor Kevin Stitt has signed a near-total abortion ban that would outlaw abortion unless it was necessary to save the life of a woman in a medical emergency. When Stitt signed the bill, he said, "We want Oklahoma to be the most pro-life state in the country. We want to outlaw abortion in the state of Oklahoma." Reproductive rights groups will almost certainly file legal challenges to the law. That's not the only major development in abortion rights that took place last week. The 2 abortion clinics in Kentucky have stopped providing abortion services. The clinics said they couldn't comply with the terms of a new state abortion law that went into effect last week. This makes Kentucky the first state to prohibit virtually all in-state abortions at any stage of pregnancy under all circumstances. Reproductive rights groups have filed 2 lawsuits in federal court against the Kentucky law. The fate of abortion bans in Oklahoma, Kentucky, and many other states could be determined by the U.S. Supreme Court's decision in Dobbs v. Jackson Women's Health Organization, which the court is expected to decide this summer. In that decision, the Supreme Court could decide to overturn or limit Roe v. Wade, a 1973 decision that protects a pregnant person's right to obtain an abortion prior to fetal viability. Next, we'll read the near-total abortion ban recently signed into law in Oklahoma. Senate Bill 612. Subject: Abortion. Be it enacted by the people of the state of Oklahoma. Section 1. New Law. A new section of law to be codified in the Oklahoma statutes as Section 1-731.4 of Title 63, unless there is created a duplication in numbering, reads as follows. As used in this section, the terms abortion and unborn child shall have the same meaning as provided by Section 1-730 of Title 63 of the Oklahoma statutes, and medical emergency means a condition which cannot be remedied by the delivery of the child in which an abortion is necessary to preserve the life of a pregnant woman whose life is endangered by a physical disorder, physical illness, or physical injury, including a life-endangering physical condition, caused by or arising from the pregnancy itself. Notwithstanding any other provision of law, a person shall not purposely perform or attempt to perform an abortion, except to save the life of a pregnant woman in a medical emergency. A person convicted of performing or attempting to perform an abortion shall be guilty of a felony punishable by a fine not to exceed $100,000 or by confinement in the custody of the Department of Corrections for a term not to exceed 10 years, or by such fine and imprisonment. This section does not authorize the charging or conviction of a woman with any criminal offense in the death of her unborn child, or prohibit the sale, use, prescription, or administration of a contraceptive measure, drug or chemical, if the contraceptive measure, drug or chemical, is administered before the time when a pregnancy could be determined through conventional medical testing, and if the contraceptive measure, drug, or chemical is sold, used, prescribed, and administered in accordance with manufacturer instructions. It is an affirmative defense to prosecution under this section if a licensed physician provides medical treatment to a pregnant woman which results in the accidental or unintentional injury or death to the unborn child. So, that's it. That's a fairly short law. That is Oklahoma's new law banning abortion in almost every circumstance, with the only exception being if the abortion is necessary to save the life of the pregnant woman. The ban does not contain exceptions for rape or incest, just like with the Missouri trigger ban we read in the last episode of Primary Sources. If this law takes effect, and you're a woman who is raped in Oklahoma, you cannot legally obtain an abortion in the state in which you live. You would have to travel outside the state in order to receive an abortion to terminate the pregnancy which you received as a result of being raped. In addition to not having an exemption for rape or incest, this law does not have an exception for the health of the woman unless it's a life-threatening injury or condition that would be averted. So this makes Oklahoma's near-total abortion ban even more intense and extreme than the one in Missouri, the trigger ban that we read, because that one at least provided an exception for serious physical injury to the pregnant woman, in addition to if the abortion was necessary to save the woman's life. And like the Missouri ban, there is no minimum threshold under which it is legal to get an abortion under all circumstances. It is a total ban at any stage of pregnancy, with only one exception, which is to save the life of the pregnant woman. Once again, this bill, like the Missouri law, does not provide criminal penalties for a woman who obtains an abortion, but because it provides criminal penalties, both in terms of a possible prison sentence and or a possible fine for the doctor carrying out the abortion, it eliminates the woman's right to obtain an abortion because no one can legally provide it to them within the state in which they live. So that is the Oklahoma near-total abortion ban, which has been signed into law. Specifically, the legislative history is that the Oklahoma Senate passed the near-total abortion ban on March 10th, 2021. The Oklahoma House passed the bill on April 5th, and Oklahoma Governor Kevin Stitt signed the bill into law on April 12th. Next, we're going to look at the impact of the abortion ban in Texas that went into effect last year. A study by the Texas Policy Evaluation Project at the University of Texas at Austin examined the impact the Texas 6-week abortion ban has had on the number of Texans seeking out-of-state abortion services. The study found a dramatic increase in the number of Texas women receiving out-of-state abortions following the implementation of SB 8 on September 1st, 2021. Researchers collected data from 34 of 44 open abortion care facilities in Arkansas, Colorado, Kansas, Louisiana, Mississippi, New Mexico, and Oklahoma, where they expected Texans to travel based on past reports. In August 2021, the month prior to the implementation of SB 8, 235 Texas residents received abortion care at one of these 34 facilities. Between September and December 2021, an average of 1,391 Texans obtained abortions at these out-of-state facilities per month. That's almost 6 times the number of Texans who received out-of-state abortion care in the month before SB 8 came into effect. The comparison remains true when comparing the number of Texans who received out-of-state abortions in 2021 after SB 8 to the same period in 2019. From September to December 2019, Texas residents received 514 out-of-state abortions. From September to December 2021, Texas residents received 5,574 out-of-state abortions. This represents an almost 11-fold increase from 2019. More Texas women received out-of-state abortion care in Oklahoma than any other state. 45% of Texans who traveled out of state from September to December 2021 obtained abortion care in Oklahoma. The nearest Oklahoma facility is over 3 hours away from Fort Worth, Texas, and 7.5 hours away from Houston. To obtain an abortion in Oklahoma, women must first receive state-directed counseling and then wait at least 72 hours. If the Supreme Court overturns Roe v. Wade, and Oklahoma's near-total abortion ban came into effect, Texas women would have to find another state to receive abortion services. Oklahoma women seeking an abortion would have to travel to another state to obtain an abortion as well. The study determined the second most common state for Texans who received out-of-state abortions was New Mexico. 27% of Texas women who received out-of-state abortion services traveled to New Mexico. Most metropolitan areas in Texas are over 4.5 hours away from a New Mexico abortion care facility. New Mexico does not require state-mandated counseling or waiting periods for patients seeking abortions. The study quoted a 36-year-old Texas woman who traveled to Oklahoma to receive an abortion, who expressed her frustrations with her state's abortion ban. "You really can't find out that you're pregnant until you're about 6 weeks," she said. "Your body doesn't notify you of that. By then, you're already having a heartbeat. It really is just a setup for fuckery, if I can just be honest. It's just not fair because it just doesn't give you a fair chance to make a decision in your home state. I just feel bad for those who are in less of a fortunate situation than I was, because I was able to figure it out." You can read the full study by clicking the link in the description. The Supreme Court may very well overturn Roe v. Wade. As the U.S. faces the possibility of a post-Roe world, we may benefit from learning about the experiences of women who sought abortion services before Roe was decided. University of Chicago law professor Jeffrey Stone wrote Sex in the Constitution, Sex, Religion, and Law from America's Origins to the 21st Century. The book examines American attitudes and laws regarding contraception, abortion, LGBT people, and pornography throughout American history. The book is an outstanding and fascinating look at the deep roots of some of America's oldest cultural and political debates surrounding sex and sexuality. If you're interested in these topics at all, I highly recommend this book. Stone described the experiences of women seeking abortions prior to the Supreme Court's 1973 decision in Roe v. Wade. I should warn you, this passage contains fairly disturbing descriptions of back-alley abortions. The situations he describes are upsetting, but important to know as the U.S. prepares to possibly return to the policies that prompted women to resort to these dangerous options. Stone's descriptions of the horrors of back-alley abortions is the strongest and most persuasive argument for abortion rights I have ever encountered. Before Stone discussed back-alley abortions, he described the safer options available to more affluent women. The following passage can be found in Chapter 16, The Road to Roe, on page 372. Some of the approximately 1 million women who resorted each year to unlawful abortions were fortunate enough and wealthy enough to find doctors willing to perform such abortions. The going rate for an illegal abortion performed by a qualified physician was typically in the range of $1,000 to $1,500, approximately $8,000 to $12,000 in today's dollars. Some physicians who believed women had a right to control their own bodies and destinies performed legal abortions for only a nominal fee. Dr. S. in New York, for example, performed more than 30,000 illegal abortions during his career for an average fee of only $50 to $100. Most women who could afford to pay a doctor to perform an illegal abortion were married, wealthy, and well-connected. Even for them, though, it was frequently difficult to find such physicians. Often, they would have to ask friends whether they knew anyone who knew anyone, an inquiry that could be quite mortifying. To avoid that humiliation, some women who could afford to do so, like Sherry Finkbein, left the country to get a legal abortion elsewhere. The vast majority of women who found themselves facing the dilemma of an unwanted pregnancy could not afford either to leave the country or to pay a physician to perform an illegal abortion in the United States. Instead, they turned either to dangerous self-induced abortions or to the dark and often forbidding underworld of untrained and unreliable back-alley abortionists. Women who resorted to self-induced abortions typically relied on methods such as throwing themselves down a flight of stairs, or ingesting, douching with, or inserting into themselves a chilling variety of chemicals and toxins, ranging from bleach to potassium permanganate, to turpentine, to gunpowder, to whiskey. Knitting needles, crochet hooks, scissors, and coat hangers were among the tools commonly used by women who attempted to self-abort. Approximately 30% of all illegal abortions were self-induced. Women who sought abortions from back-alley abortionists encountered similar horrors. To find someone to perform an illegal abortion, women often had to rely on the advice of friends or acquaintances, or on tips from elevator operators, taxicab drivers, salesmen, and the like. Because of the clandestine nature of illegal abortions, the very process of finding an abortionist was often dangerous and terrifying. Women who sought back-alley abortions were sometimes blindfolded, driven to remote areas, and passed off to people they did not know and could not even see during the entire process. Such abortions were performed not only in secret offices and hotel rooms, but also in bathrooms, in the back seats of cars, and literally in back alleys. The vast majority of these abortions were performed either by persons with only limited medical training, such as physiotherapists, midwives, and chiropractors, or by rank amateurs, including elevator operators, prostitutes, barbers, and unskilled laborers. In the 1960s, an average of more than 200 women died each year as a result of botched illegal abortions. The mortality rate for Black and Hispanic women was 12 times higher than the mortality rate for white women. In addition to those who died in the course of illegal abortions, many thousands more suffered serious illness or permanent injury. Because of the humiliation associated with having an illegal abortion, many women who suffered complications were reluctant to visit a doctor for treatment. The stories of women who suffered through this nightmare are legion. One woman recalled how a fellow college student who had an illegal abortion was too frightened to tell anyone what she had done. She locked herself in the bathroom in her dorm and quietly bled to death. In another incident, 28-year-old Geraldine Santoro bled to death on the floor of a Connecticut hotel room after she and her former lover attempted an abortion on their own. The former lover, who had no medical experience, used a textbook and some borrowed tools. When things went terribly wrong, he fled the scene, and Santoro died alone. The former lover pled no contest to manslaughter and served a year in prison. As I discussed in the last episode of Primary Sources, 21 states have laws on their books that could allow them to swiftly ban abortion if the Supreme Court overturns Roe v. Wade. Almost overnight, abortion could become illegal in large swaths of the American South and Midwest. To obtain an abortion, women in these states will either have to travel to another state, obtain an illegal abortion from a doctor willing to break the law, or resort to highly dangerous, self-induced, or back-alley abortions. Women who lack access to legal and safe abortion services in their state, especially poor women, will be at risk of desperate and tragic deaths from dangerous back-alley abortions. This, more than anything else, is the risk we take if we eliminate abortion rights in the United States. If Roe is overturned, legal abortion services will still be available in more states than it was before Roe began protecting abortion rights nationwide in 1973. In a post-Roe America, fewer women would likely die from back-alley abortions than in the 1960s. But if abortion remains safe and legal nationwide, no women would die under these terrifying circumstances. This is what's at stake when the Supreme Court decides Dobbs v. Jackson this summer. That concludes this episode of Primary Sources. Join me next time on Primary Sources as we continue to examine the primary sources behind today's top stories.